very quickly. Dr. Lani Pekon is a lead partner at Asher and Macarius law firm. He heads the dispute resolution and policy advisory group of the firm. Oladapo holds a Bachelor of Law degree from the University of Lagos, as well as a master's degree in corporate and commercial law from the Center for Commercial Law Studies, Queen Mary University of London. He also holds a PhD in law from the International Financial Law Unit of Queen Mary University of London. He is the editor-in-chief of the Banking and Financial Law Reports. He is also the chairman of the advisory board of the Constitutional Rights Awareness and Liberty Initiative. Dr. Oladapo was elevated to the rank of Senior Advocate of Nigeria in 2015 and holds the record of being the youngest person ever to be conferred with the rank since its inception. Dr. Oladapo Pekon, could you tell us, what do you think are the fundamental changes that innovations being proposed? Where are we today? Thank you. Dr. Lani Pekon is a lead partner at Asher and Macarius law firm. He heads the dispute resolution and policy advisory group of the firm. Oladapo holds a Bachelor of Law degree from the University of Lagos, as well as a master's degree in corporate and commercial law from the Center for Commercial Law Studies, Queen Mary University of London. He also holds a PhD in law from the International Financial Law Unit of Queen Mary University of London. He is the editor-in-chief of the Banking and Financial Law Reports. He is also the chairman of the advisory board of the Constitutional Rights Awareness and Liberty Initiative. Dr. Oladapo was elevated to the rank of Senior Advocate of Nigeria in 2015 and holds the record of being the youngest person ever to be conferred with the rank since its inception. Dr. Oladapo Pekon, could you tell us, what do you think are the fundamental changes that innovations being proposed? Where are we today? Thank you. You need to unmute your mic.
Okay, good afternoon again, and thank you for the question. Thank you to Professor Suskind, the co-panelists, and the participants. I'll just start from a very broad, on a very broad basis, and I'd like to use a quote from David Mello, a man I believe did not like lawyers that much. So he says about lawyers, he says that lawyers are like rhinos, that they are thick-skinned, they are short-sighted, and they're always ready to charge. And I don't think many will disagree with that quote, apart from lawyers themselves. There's this perception of lawyers that we are generally resistant to change. But the landscape of the legal market has been changing for years, I think for about a decade now, and many factors have been responsible for that. The primary factor has been technology, but there have been other factors like the economic conditions, globalization, the rise in consumerism. We've had also a mix of about 5 generations in the workforce at the same time. So we have a multi-generational workforce. So things have been changing, but somehow lawyers have been getting by. I think it's also important to understand the philosophy that kind of underpins our profession, what I would call a precedential philosophy. So lawyers have this thing that we call judicial precedent, stare decisis as it is called, where we use the past to determine today and to determine the future. So sometimes we have the thoughts and the experiences of people that now lie in their graves, determining how we carry on our lives today. Now, it's not necessarily a bad thing, and many lawyers will explain to you that the purpose of this, the essence of this, is certainty. So we try to achieve certainty in the law. Now we are in uncertain times. So, and there isn't much that the past can do to help today or to help the future. We're experiencing things that I think the word everybody uses now is that these are unprecedented times. And so change is being forced on us. And like Mr. Kemi Pinero, SAN, said, he said, necessity is the mother of invention. Indeed, there is a principle of law known as the doctrine of necessity itself. So it's kind of an existential challenge for us as lawyers. One from a business perspective, and the second is from the perspective of access to justice. From a business perspective, we think about it in terms of business continuity. So all of a sudden, nobody was prepared for this, I have to say. It started in China, America wasn't prepared, Europe wasn't prepared, and we certainly were not prepared for it in Nigeria. So I think it was a weekend in the third week of March, we all left work, and then all of a sudden we were cut off from our staff and we're cut off from our offices. Now, this is essential for business continuity. Most of us have to have access to the premises and access to staff. And this is what then leads on to access to clients. Now, apart from a few firms that have embraced technology, who kind of saw the changes coming, a few firms, most other firms have been unable to function. And that's the truth. And there's been the domino effects of lawyers now not being able to earn a living because of this, just because we weren't prepared for this pandemic and the way it will affect our practice. Second is in terms of the relevance of lawyers. So what we've seen all across the world is that there's been a shutdown in every sector. And we have only what you would call essential services function of colleagues. And I'll say, hold on, it appears that lawyers are not essential after all, because everybody else that is essential is out there and doing their business one way or the other, but lawyers are not doing their business. Everything is practically shut down. That's also interesting from a constitutional perspective, because if we look at sections 4, 5, and 6 of our constitution, we have a system of separation of powers embedded in there, where we have the legislature, the executive, and then the judiciary. And as we all understand it from constitutional jurisprudence, that we need to have all three functioning at the same time. Otherwise, we would have tyranny. So in Nigeria, what we've had effectively for the past 5 weeks is that we've had the executive perhaps operating at full throttle. The legislature, we've had them every now and then, we see them come up there, but the judiciary has disappeared completely. And I do not think any society wants to be without a judiciary. That's where we find ourselves. And so apart from the risk to business, the risk to our existence, our relevance, is also that access to justice has been effectively cut off. And there is a risk that there is an emerging tyranny. And if you want to understand what I'm talking about, I was told yesterday I saw a draft of a bill that perhaps has been shot down at the National Assembly. And it's a bill to, I think it's called the Infectious Diseases Act, the Infectious Diseases Bill. And this bill introduces wide range of powers, sweeping powers on the Director General of the NCDC and the Minister for Health. Now, if you read the bill, and again, I cannot verify the authenticity of the version that I read, but what I saw from that version is that virtually every right in Chapter 3 of the Constitution be affected. Right to dignity of the human person, right to privacy, right to life itself, right to liberty, right to fair. Now, the DG of the NCDC has wide powers, arbitrary powers to take actions that may impugn on these rights. And then if you look at the recourse that the citizen has, I saw a section there that says that if you agreed, who do you appeal to? You appeal to the Minister for Health within 7 days. So effectively, the courts are being overlooked because that law presupposes that every time there is a pandemic or there is a challenge, because of the way our courts are structured, then the courts will go comatose. Now, that's very important, and we need to start looking at that, because how important are we? And will our businesses survive if we carry on the way we are going at the moment? So the change, as it were, is being forced on us as lawyers at this time. I would share a personal experience also, which was that we had a cause to deal with an emergency, but well, as such, it was a case of defamation. And then we had to write a cease and desist letter to the person involved. And we took the time and wrote a letter of about 3-4 pages. And all we got in response by email was, LOL, go to court. A person involved knowing that there is no court to go to at the moment. So I think right now we have no choice than to embrace change. I would have to say I'll just go idiomatic, taking a cue from Mr. Kempinero. He said that necessity births invention. I think the question we need to be asking ourselves is whether we can fix our roof while it's leaking. I think that's where we have the challenge right now.
Thank you very much, Dr. Lani Peko. And you literally echoed what Professor had said, that should people be denied access to justice just because there is a pandemic and because the necessary technology is not in place? Leonard Silk, Philip had raised a very critical point, which I think our attendees will really be interested in. And that is the fact that they're using already existing laws and procedures. Like he mentioned, the Coronavirus Act of 2020, which has already been passed. I imagine that that law envisaged or has captured video conferencing in courtrooms. What do you think? Do we already have an existing draft for such a similar act here in Nigeria?
The judge's very broad interpretation of the existing rules.
Thank you, Philip. Hello, Philip. I was asking SAN to stress your point, just
right.
what you had said. I wanted him to, thank you. Leonard Silk.
Thank you very much. So I think the closest we would have to that would be the provisions and the various rules of courts dealing with hearings that are purely documentary. So, for example, with where you have affidavits, where you have written addresses. And so with these hearings, I do not think that counsel needs to be in court, and litigants do not have to be in court as well. Now, the question in Nigeria is whether the judge can then, from a remotely, constitute the court and then adopt these addresses. The challenge, again, I would say, is the somewhat technical nature of adjudication. And we would all recall the Supreme Court decision in Menakaya, where for convenience reasons, two senior counsel approached the court, actually filed applications and said, well, let's be heard in chambers. So that's not remotely, they just moved from open court to the chambers, and both parties agreed. And then the decision went against one party, and then the other party challenged it. And then the Supreme Court said, well, there is a constitutional imprimatur that court hearings must be held in public. So that's in section 36, subsection 3. I think that's the bit of the challenge that we may have here in terms of existing rules. Now, I think there is an exception on that subsection 4 that says that public hearing can be dispensed with where there are matters of health and public safety and things like that. Now, whether the hearing can move from the courts to a remote location is something else. Now, I would say that what is not expressly forbidden is allowed. So perhaps we can it's something we can explore here. It's just that I would like to also say that my attention was drawn to a circular yesterday from one of the heads, or from the head of one of the courts to the judges, saying to them to desist from remote hearings. And the reason for this, because my Lord, the Chief Justice of Nigeria has not issued any guidelines it. Now, I read that, and then I was wondering, because all the courts created on the Part 7 of the Constitution, the heads of courts have the prerogative to issue guidelines as to practice and procedure. There is no such power for the NJC. Lord the Chief Justice of Nigeria can issue guidelines as to practice and procedure for the Supreme Court, not for the other courts. If you look at the first part of the third schedule, the closest you see there is that the NJC has powers relating to policy and administration. Policy and administration is completely different from practice and procedure. So while there's nothing stopping us from going ahead with such remote hearings, as far as we're just going to deal with documentary hearings. But it's a matter of judicial attitude, I think.
Thank you very much, Leonard Silk.